So good afternoon, everyone, and welcome to our first webinar in the 2023 Canadian Trademark Series. My name is Graham Hood, and I'm a principal with the Trademarks Practice Group here at Smart & Biggar. Together with my colleague, Laura Easton, we will be delivering this afternoon's webinar, Contentious Trademark Proceedings in Canada. I'd like to start with a couple housekeeping matters. Our formal presentation will last for about 45 minutes and will be followed by an open and interactive Q&A session where we'll address your specific questions that you may have on various matters raised during this afternoon's webinar. We also encourage you to submit questions at any time during the presentation by typing them into the Q&A panel, which can be accessed by clicking on the Q&A button at the bottom of your screen. Please do not type your questions into the chat panel. We will try to address as many questions as we can in our live session, and of course, follow up by email after today's session to address any unanswered questions. Today's webinar will be recorded, and following the presentation, we will circulate an email with a replay link together with PDF copies of the slides. At the end of this webinar, a link will pop up to complete a survey. We ask that you take a few moments to complete the survey and provide us with your feedback on today's webinar, as well as what topics you'd be interested in learning about in the future. Before we begin today's webinar, we would like to offer a land acknowledgement.
In the spirit of reconciliation, we respectfully recognize and acknowledge that the land we are meeting on and that all Canadians live on, work, and enjoy is the traditional territory of many nations. These lands are home to many diverse First Nations, Inuit, and Métis peoples, and are covered by various land treaties. In Toronto, where Graham is situated, the land is the traditional territory of the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is covered by Treaty 13. Calgary, where I join you from, is part of the traditional territories of the Blackfoot Confederacy, Siksika, Kainai, and Piikani, the Tsuut'ina, the Stoney Nakoda Nations, and the Métis Nation Region 3, and all peoples who make their homes here in Southern Alberta under Treaty 7.
Now we'll start with a brief introduction about Smart & Biggar. So today our speakers, yours truly, I'm a principal with the Trademarks Practice Group in Toronto.
My name is Laura. I practice out of our Calgary office, and I work predominantly with our litigation and trademark groups.
A bit about the firm. Smart & Biggar is Canada's leading IP law firm with expertise in the interface of technology and business law. We practice in all areas of IP, have expertise in all areas of IP, and have been serving clients for over a century. From coast to coast, we have a team of 100+ lawyers, agents, and technical consultants. 8,000 patents and trademark applications are filed annually by our offices, and an unparalleled litigation bench strength and record of success. So let's take a look at where we'll be heading today. We'll be discussing Trademark Opposition Board proceedings, court proceedings, and settlement and coexistence agreements. The TMOB proceedings will look at the different types of proceedings, the strategies to employ in those proceedings, some forthcoming developments to TMOB practice and procedure that we'll be seeing within the next couple of years, as well as what it means to appeal a TMOB decision. I'll then hand it over to Laura, who will discuss court proceedings, including what to expect in the federal and provincial courts, strategies in federal court proceedings, and some additional considerations when bringing a claim in Canada. And finally, we'll discuss settlement and coexistence agreements, things to consider when resolving your matter amicably. So for the purpose of today's webinar, we'll be discussing TMOB proceedings, which typically take one of two forms. We have opposition proceedings and we have cancellation proceedings. Opposition proceedings provide the opportunity for any person to object to the registration of an applied for trademark. It's a process that comes at the end of the application process. It's a proceeding in which the onus is on the applicant to demonstrate the mark's registrability, and it remains on the applicant throughout the proceeding And the decision can be appealed to the federal court, which in turn can be appealed to the Federal Court of Appeal. Cancellation proceedings are slightly different. There we're looking at aged registrations. It's an opportunity to clear the register of dead wood. Only registrations that are 3 years or older may be challenged, and the onus is on the registrant, the registered owner, to demonstrate use or special circumstances excusing non-use. Those two can be appealed to the federal court and subsequently the Federal Court of Appeal. So taking a look at TMOB proceedings and opposition proceedings in particular, they are a long and drawn out process. They can take upwards of 4 years or more if the parties to the proceeding take advantage of all the time extensions available to them. There are a number of different stages in the process, and each one plays a very important part. The statement of opposition is perhaps one of the most important. It sets out the grounds of opposition, which frame the entire proceeding going forward. Then the applicant has an opportunity to deliver a counterstatement, which now is a mere one line indicating that the applicant intends to defend the opposition proceeding. Then the opponent has an opportunity to deliver its evidence in chief. The applicant has an opportunity to cross-examine on that evidence. The applicant then has its opportunity to deliver evidence. The opponent has an opportunity to cross-examine on that evidence before the opponent delivers its reply evidence, if any, and the applicant has an opportunity to cross-examine on that evidence as well. Once the evidentiary stage is complete, the parties have an opportunity to file written arguments if they wish, and request an oral hearing of the matter, again, if they wish. The whole process can take several years from start to finish. It's also important to bear in mind that there is an opportunity to seek interlocutory rulings in opposition proceedings. At certain stages, the registrar may issue rulings at a party's request. For example, an applicant may seek to have a statement of opposition struck or narrowed in its scope if the statement of opposition is deficient in any respect or does not provide the proper basis for an opposition. An opponent may seek leave to amend its statement of opposition, and we'll get into that a little later. And a party may also seek leave to file additional evidence. So these are things that a party can call upon in the course of a proceeding if it needs to amend its pleadings or it needs to bolster its evidence. And these are critically important because, as we'll see, it's only what is before the registrar at the time of hearing that they will consider in coming to a decision. So opposition proceedings proceed on a number of different grounds. Those grounds are statutory in nature. They are set out at subsection 38(2) of the Trademarks Act. And these are the only grounds on which you can oppose a trademark application in Canada. There are some pretty straightforward opposition grounds, such as the application does not conform to formal requirements. For example, the goods and services as described in the application are not set out in ordinary commercial terms. The applied for trademark is not registrable, and that it's perhaps confusing with the opponent's trademark or another trademark. The applied for trademark is descriptive. The applicant is not entitled to register the mark, and that another person, perhaps the opponent, has prior rights. And the applied for trademark is not distinctive, in that it's either descriptive or there are others using the mark in the marketplace such that it cannot be distinctive of any one trader. There are also new grounds of opposition that were introduced with the recent amendments to the Trademarks Act in June of 2019. For example, the application was filed in bad faith by the applicant. The applicant is not using and did not propose to use the applied for trademark, which can be difficult to prove. And the applicant is not entitled to use the mark, which is different from the opposition ground on the basis of non-entitlement to register. For example, An applicant may not be entitled to use a mark where the use of the mark would violate federal law, or the use of the mark is contrary to an agreement between the parties, such as a franchisor-franchisee agreement or a previous licensor-licensee agreement. The statement of opposition, as I mentioned earlier, is absolutely critical because it frames the entire proceeding. It's the pleading that determines the scope of the proceeding. And if an opponent has not pled a particular ground of opposition, then the registrar will not consider it. So it's critically important that opponents are mindful of what they've pled and what they could potentially plead after new evidence comes to light, for example, in order to have all of their grounds, all of their viable grounds available to them and before the registrar at the time of a decision. The allegations underlying each ground are also critical. The registrar will consider only the ground as pled in the statement of opposition, so they will not read in any additional factors. And this comes into play in allegations of non-distinctiveness, for example, or non-entitlement. Non-distinctiveness may be based on an opponent's use. It may be based on third-party use, widespread use in the field or industry, but that needs to be set out in the opposition, in the statement of opposition. Otherwise, the registrar will not consider any other allegations outside the four corners of the statement of opposition. Non-entitlement to use must also identify a specific agreement, either between the parties or a statutory provision in respect of which the use of the mark is said to have violated that provision. The evidence filed is also absolutely critical for a number of reasons. One, the opponent bears an initial evidential burden, which means that the issue or ground of opposition will not be considered at all unless there is sufficient evidence from which it could reasonably be concluded that the facts alleged to support that ground exist. Now, this initial evidential burden will be stronger or heavier in some cases. It will be lighter in others, where, for example, evidence of use or knowledge of use is, of course, with the applicant and the applicant alone. The initial evidential burden on the opponent will be lighter as the pertinent facts are within the knowledge of the applicant and not the opponent. If an opponent has not discharged its initial evidential burden, then the registrar will not consider that ground of opposition. It is simply dismissed out of hand. But the opponent may rely on its evidence, of course. It may rely on the applicant's own evidence, and it also may rely on any evidence that comes to light by way of cross-examination. Cross-examination itself is not restricted to the four corners of the affidavit. An affiant that is put forward on behalf of a party may be questioned on anything relevant to the issues in dispute. At the tail end of an opposition proceeding, once the evidentiary stage is concluded, the parties will have an opportunity to file written arguments. These are critically important, I think more so than oral submissions at a hearing, because they are something that the hearing officer can take with them, can review, and I find they often turn the tide for most parties in most proceedings. They're now filed sequentially. Before June 2019, when the recent amendments to the Trademarks Act came into force, they were filed simultaneously. So it was almost a matter of guessing what the other party would say and attempting to counter or address that in your simultaneous filings. They're now filed sequentially, I think, which makes much more sense. So the opponent goes first and the applicant has an opportunity to answer. Oral hearings are also an optional step, strongly encouraged, and are heard by video conference in the absence of exceptional circumstances. Each party must submit a list of jurisprudence in advance, including new and unreported cases on which the party intends to rely at the hearing. After that, the decision is rendered and no costs are awarded in an opposition proceeding. For now, that will change in the next couple of years. Turning now to cancellation proceedings. These are much shorter, much more summary in nature than opposition proceedings, and they follow 3 or 4 quick and easy steps. First, a requesting party, usually a trademark agent, asks the registrar to commence the proceeding against an aged registration. And why would one wish to commence a cancellation proceeding? There are a number of reasons. One, the cited registration is blocking the applicant's application, and it needs to be cleared from the register in order to make way for the applicant's application. It may also be used in tandem with federal court proceedings to put pressure on the other side in the course of concurrent proceedings. Once the registrar issues that notice, the registrant then has an opportunity to file affidavit evidence showing use of the mark in Canada within the 3-year period preceding the date of that notice. Now, if the registrant doesn't have use of the mark, it may furnish evidence of special circumstances excusing non-use, but that's a high bar, and it is not something that will be granted in every case. We'll get into that in just a moment. Notably, there's no cross-examination in cancellation proceedings. The registrant and its affiant will not be questioned on the affidavit, but it should be airtight, it should be clear and concise and explain exactly how the registrant has used the mark in Canada and provide specimens of use. The parties then have written arguments and again may request an oral hearing. As I mentioned, cancellation proceedings are supposed to be expeditious, simple, and summary in nature. Unlike an opposition proceeding, which can take 4+ years, cancellation proceedings typically take within 2 years or less. Turning to the evidence of use, the burden of proof is low. This is consistent with the simple summary nature of the proceedings. The registrant need only show that its trademark is in use. It need not show every example of use, every instance of use, but it does need to demonstrate to the registrar that the mark is in use and the marked goods are being offered for sale and sold, the services are being offered and performed in association with the mark. The jurisprudence is clear that this is not a proceeding where there should be a, quote, infinite contestation of the facts. We talked briefly about special circumstances. Special circumstances excusing non-use call for a 3-part test, and the courts have often analyzed special circumstances by using these 3 criteria, considering the length of time during which the trademark has not been used, the reasons for non-use, which must be beyond the registered owner's control, things like an act of God, for example, and one must find that there exists a serious intention to shortly resume use. So it's important that a registrant provide evidence of positive steps that they are taking towards recommencing use in Canada. The evidence is technical in nature. It has to tick a number of boxes and it has to tick all of them. First of all, it needs to show evidence of use of the mark as registered or an immaterial variant thereof. So one tricky issue is where the mark as used does not reflect the mark as registered. And the registrar and the court on appeal will consider a couple of questions in determining whether that immaterial variant is in fact immaterial. For example, the court will ask, is the public likely to perceive the mark as used as a trademark? Is the registrant using this immaterial variant as a trademark? And is the trademark as used not substantially different from the mark as registered, such that any deviations are unlikely to deceive or injure the public? will the public still consider the mark as used to be that of the registrant, and that being the registered mark on file? It's also important to evidence use of the mark with the goods and services. The goods and services as described in the registration, which can get tricky because in some cases your registration may be decades old and we don't use those terms to describe those goods or those services anymore, in which case the registrar will have to indulge the registrant somewhat, not undertake a deep dive into the linguistics of the registration, but rather consider how those goods might be described in today's day and age. It's also important where the registration uses very technical terms to describe the goods or perhaps the services. It's important that the registrant's affiant specifically identify the goods that are offered for sale and sold and tie them back to the terms in the registration. Otherwise, the registrar may find that there has been use, sure, but it has not been use in association with the goods as described in the registration. And Section 4, in this case, is critical because it defines how a mark may be used in association with goods and services. There are different tests or different criteria for goods as there are for services. It's also important to note where the mark is being used. It has to be in Canada. The registrar will not consider use of the mark made outside of Canada. The mark also has to be used by the registrant or by a licensee, for example. We have to be aware the principle of trademark exhaustion. The registrar will not consider, for example, so-called use of the mark that's made on aftermarket websites like eBay. It has to be use of the mark by the registrant or by a licensee under the direct or indirect control of the registrant. And then finally, the use needs to be made during the relevant period. This is the 3-year period preceding the notice date. The registrar really will not pay any mind to evidence of use outside that 3-year period. It doesn't matter what use, if any, the registrant has made of its mark after it received that notice. It's the 3-year period preceding the notice date. Some forthcoming developments that I quickly wish to touch upon. Cancellation proceedings currently take only about 2 years. However, there is discussion of a pilot project to expedite the issuance of decisions in certain cases. The Trademarks Opposition Board is currently considering expediting decisions where the registrant does not request an extension of time to file its evidence of use, and neither party requests an oral hearing, in which case the proceeding is fast-tracked and a decision is expedited and delivered sooner than usual. However, this pilot project has yet to be launched. So as of April 1st, the delay to schedule a hearing in both an opposition proceeding and a cancellation proceeding will be reduced from 2 years to 15 months. And the opposition board's delay to issue a decision in those cases without a hearing will be reduced from 18 months to approximately 1 year, again, for both types of proceedings. Some interesting developments to consider. These are not yet in force, but they will be likely within the next year or two. The registrar will be assuming new powers. Forthcoming amendments to the trademarks regulations will empower the registrar to award costs in certain circumstances, such as where an application is successfully opposed on the basis of bad faith, or where one of the parties demonstrates sharp or unreasonable practice. The registrar will also have the ability to issue confidentiality orders on the party's request in certain circumstances and manage cases in certain circumstances, much like the powers available to an associate judge in the federal court. Case management powers will also become available to the registrar in the opposition board. These amendments have not yet been drafted. They're not expected to come into force until later this year at the very earliest, but chances are we won't be seeing these amendments in force until 2024 and beyond. So once the registrar issues a decision, a party has the opportunity to appeal it to the federal court and in turn to the Federal Court of Appeal. Appeals to the federal court are allowed as of right, and currently in both opposition proceedings and cancellation proceedings, additional evidence may be filed on appeal as of right. New evidence filed in appeals of cancellation proceedings, notably, are subject to cross-examination, whereas before the board, they are not. Any evidence filed before the court on appeal may be subject to cross-examination. So something to consider when an unsuccessful registrant appeals the decision of the opposition board. However, the requesting party in an appeal is still not permitted to file its own evidence. Before the opposition board, only the registrant files its evidence. It's the same thing on appeal. It's only the registrant that has the opportunity to file evidence. Forthcoming amendments, however, will require a party to seek leave of the court to file additional evidence. We don't yet have a timeline on these forthcoming amendments. They have not yet been drafted, but we expect to see them in the next couple of years. Notably, on appeal of an opposition board decision, the court may award costs even if a party does not participate in the appeal. So that's something to consider when either defending or commencing an appeal to the federal court. With that, I will turn it over to my colleague, Laura, who will tell us a little bit about court proceedings in Canada.
Thank you, Graham. So the last slide of Graham's is a good segue into the next one, because it talks about appeals to the federal court. The federal court is the appellate level of those TMOB decisions. And Graham, if you want to flip to the next slide, thanks. It also has exclusive jurisdiction over other relief, such as amending the register. It is, however, a creature of statute, which means it's limited in what it can hear. It basically hears causes of action arising from federal law, including the Trademarks Act. In some narrow circumstances, if there are common law allegations that are inextricably linked to a statutory cause of action, they may allow those in as well. It is a single unified court, so although there are several different courtrooms across the country, it's not broken into districts. It does operate on the same rules, and the judges will actually travel out to the other locations for sittings. There are also provincial court systems in Canada. Those are across the different provinces and territories. They do have broader jurisdiction than the federal court. They can also hear matters related to provincial statutes, and in common law provinces, they're hearing the common law torts as well. Those provincial court systems, however, they do not have that power to amend the register. And this is perhaps one of the reasons that we see the federal court as the more common venue for IP proceedings. Because it's the more common venue, the federal court is the court that we're focusing on today. Next slide, please, Graham. Thank you. The advantages of the federal court, in addition to that relief that the provincial courts may not grant, it is also a lot quicker typically to obtain hearing dates, which in turn can make it quicker to get to trial, especially if you end up having a lot of interlocutory motions along the way. Enforceability is a major component, I think. If you do have, for example, infringing activity that is taking place in multiple Canadian provinces or territories, a federal court order is immediately enforceable across the country. If you were to go through the provincial courts, you could get an order, but you're typically going to then need to go through reciprocal enforcement legislation to recognize and enforce it in the other provinces. Lastly, the judiciary is wonderful in the federal court for their familiarity with IP matters. This might be because of that exclusive jurisdiction or those appeals that it ends up hearing more IP, but also the court has intentionally appointed to the bench various former IP practitioners. So there's also a lot of the judiciary that has experience prior to the bench in IP, in addition to those who have gained that experience throughout hearing a number of decisions during their careers. There is also a very new pilot project for a specialized IP chambers, and that has a list of specific adjudicators that will be assigned both IP and competition matters. This project started, I think, just over a month ago, and the notice indicates that they are going to also try to keep in mind any subspecialties within IP as well. So federal court proceedings can typically be divided into actions or applications. An application is commenced by application. It is supported with affidavits, and you will have cross-examination as well. However, there is no discovery. You do see this most commonly with the appeals of the TMOB decisions or with Section 57 expungement proceedings. Those are where an interested person can seek to invalidate an existing registration, either because the trademark was not registrable at the date of registration, the trademark is no longer distinctive, the trademark has been abandoned, the applicant for registration was not the person entitled to secure it, or the application was filed in bad faith. In some instances where there's a very clear-cut infringement case, where that infringement is blatant and obvious, and you're more concerned with getting an injunction than you are about collecting damages, you may elect to proceed by application as well. An action, conversely, is, I guess, what you would typically consider as full-scale litigation. It includes pleadings. It will also typically include full discovery and a full trial with live witnesses if you get that far down the road. This is started by a statement of claim, and it's where you would generally expect to see actions for trademark infringement, passing off, depreciation of goodwill, etc. I do, I guess, take a brief moment to note for any American colleagues on the line today that Canadian discovery is generally narrower than US discovery. Each party puts forward a single corporate representative for examination, and the party selects which corporate representative they're putting forward. Additionally, there's no exchange of lists of requests for documents. Typically, each party just has a positive obligation to produce any records that are relevant to the issues in dispute. If you do find yourself in an action with full-scale litigation, you do still have the ability to try to, I guess, get out before discovery or trial. There are a number of tools to do so. And we'll flip to the next slide, Graham, please. So these first couple tools aren't going to necessarily help you get out of the litigation before discovery or trial, but they are very useful. Case management is where you can have a justice or associate judge who's appointed to the file to help the parties resolve interlocutory issues leading to trial. This is really helpful for scheduling, but also by appointing a specific individual, they really become familiar with the parties and the issues, and that can be really helpful for resolving interlocutory matters that arise during the proceedings. The federal court also has a publication for case and trial management guidelines for complex proceedings. This is a guide set by the court that sets out limits or guidelines regarding discovery, expert witnesses, and pretrial preparation. Some of the other tools for efficiently managing a federal court action include interlocutory injunctions pending trial. Now, these are available in limited circumstances. Effectively, the test where you need to be able to satisfy the court is that there's a serious issue to be tried, that the requesting party is going to suffer irreparable harm if the motion is not granted, and that the balance of the balance of convenience favors the requesting party. Now, the primary reason it is difficult to get is demonstrating that that harm would be irreparable. And that because it's an interlocutory motion, I do note that it is also something that's going to be based solely on affidavit evidence and, again, any cross-examination. One of the other tools for efficiently managing a federal court action and in many cases shortening it is dispositive motions. And I will discuss more on those on this next slide. There's a few different ones listed here, and they're basically various ways that you can use to shorten the litigation process. So default judgment is available where there's a failure to deliver a statement of defense. I do note that in the federal court, the allegations are not taken as automatically granted. You do still need to prove your case. There's also motions to strike. Generally, these would take place early in the proceedings, often before the other party pleads over the deficiencies. The different bases for motion to strike are where it discloses no reasonable cause of action or defense, where it's immaterial or redundant, where it's scandalous, frivolous, or vexatious, or will prejudice or delay the fair trial of the action, where it constitutes a departure from a previous pleading, or where it's otherwise an abuse of process of the court. If you do not fall under those kind of two ones that we see at the beginning of litigation, there is also summary judgment and summary trial. Both of those are available after a defense has been filed. Summary judgment is a motion for final resolution on one or more issues in the litigation where there's no genuine issue for trial. It is entirely a paper evidentiary record, but you would still have oral argument. Summary trial, where the court is satisfied that there's sufficient evidence for adjudication and it would not be unjust to do so. This is considered kind of the slightly more in-depth version of summary judgment, I suppose. It is similarly not a full trial, but in this case, you have the ability to include live evidence with leave of the court. Often what you'll see is affidavits being filed, but then the arrangement for live cross-exam during the hearing as an example. And again, these are options that are available once a defense has been filed. So where a party does think it has a very strong case, it might even try for one of these proceedings prior to discovery, which, as we all know, can stop litigation before you get into some of the most expensive parts of it. Additional considerations, we just wanted to briefly touch on this because if you are litigating a trademark that is not yet registered, you may want to take it as an opportunity to try to fast track any pending trademark applications for that mark. You can also even use contemplated litigation as a basis for expedited examination. I won't go into that any further because my colleagues Quan Lo and Nora Labance will be talking about that at their webinar on June 15th, 2023. So I encourage all of you to register.
So that brings us to the final topic today, settlement and coexistence agreements. Both opposition board proceedings and federal court proceedings have the option of ending amicably. In fact, in most cases, proceedings will settle out before they reach a final decision. Certainly in the opposition board, I would say 80% of cases, if not more, will settle before the registrar issues a decision. And I imagine that the numbers are similar in federal court. The fact of the matter is, both opposition board proceedings and federal court proceedings are extremely expensive, and they're also uncertain. So if the parties can save a bit of money and can reach an agreement, a resolution that is certain, it usually stands to benefit everyone involved.
So with respect to settlement, the first thing to note, at least in the litigation context, is that offers to settle can trigger cost consequences in a number of court systems. So if, for example, one party makes a formal offer to settle and the other party rejects it, if that other party, if ultimately at court, the final award is less favorable than the actual offer that was refused, that can create cost consequences. So in many cases, a formal offer may encourage settlement to a greater degree because of that consideration.
Laura, we've received a question about settlement of opposition board proceedings. In practice, what success rate do you have, if any, settling opposition and cancellation proceedings prior to formal submissions? That is, by sending out without prejudice letter? Or would you suggest commencing proceedings prior to sending any negotiation type letter? In my experience, 80% of board proceedings typically settle out before they reach an ultimate decision. I always think it's a good idea to raise negotiation early, and that can mean raising it at first instance before any proceeding is in fact commenced. In some cases, an opposition can be avoided entirely by reaching out to the applicant in advance, identifying certain goods and services in the application that cause your client distress, asking that they strike those goods and services, and asking for an undertaking not to use the mark in association with those goods and services. I've had many cases like that where the parties have avoided an opposition proceeding altogether with simply a few nips and tucks of the application. Similarly, in cancellation proceedings, usually you'll commence the proceeding before raising the prospect of settlement to put some pressure on the registrant. The registrant's registration is not yet at risk unless and until the proceeding is commenced. So what we'll often do is we will commence the proceeding. We might follow up with a letter saying, look, we're really only interested in this good or this service or these goods and these services. If you voluntarily delete them, we can withdraw our cancellation proceeding. And we've had some success in that regard.
If you are looking at a settlement agreement, some of the terms ultimately the terms are going to depend on the nature of what the parties agree to and the nature of the dispute between them. Commonly, those terms are going to include injunctive undertakings or licensing arrangements between the parties, terms of payment. If there's any proceedings underway relating to the dispute, they'll also commonly have terms for concluding those proceedings, whether that's a consent judgment, a discontinuance, or a withdrawal, depending on, well, one, whether you're before the board or whether you're before the court, and two, the desire of the parties. Often, obviously, some parties would prefer a discontinuance of a court proceeding over a consent judgment. With legal costs, you just want to be clear about any legal costs that are payable, or if that agreement is on a without cost basis. This can be particularly important in court proceedings, depending on the jurisdiction that you're operating in. A discontinuance might automatically entitle the defendant to costs unless the parties expressly consent that that discontinuance is on a without cost basis. And obviously, you want to consider a release. That's a very common term, and depending on the dispute between the parties, it might be a one-way release, it might be a mutual release.
Coexistence agreements are an alternative to settlement agreements, and you will occasionally see them in opposition board proceedings. I think less so in federal court proceedings. And it's where the parties agree that they can coexist, that they can carry on their merry way and continue to do business in Canada in the same or perhaps separate marketplaces under certain terms that are typically set out in the agreement. The terms of the agreement are usually informed by the commercial reality, and really the limits to the agreement are, well, there are few. The agreement's limited only by the party's imagination, and it will depend on what the parties do, how they operate, the goods and services that they offer, their customer bases. All of this informs what the coexistence agreement will look like. So an agreement may define or restrict the parties' fields of use or operation, the goods and services that they can continue to offer to persons in Canada, the jurisdictions or areas in which they continue to do business, their trade channels, how do they offer their products to people, how do they advertise, their trademark filings going forward, are they allowed to file marks or applications for those marks, or do they have to withdraw their applications? And also trademark use, how are they going to in fact use the mark going forward? These are all things that need to be considered when crafting these agreements. One other option, I don't have it written down here, it's something that I've seen more of, particularly in the US, are so-called straw man applications, where parties will agree that their marks can coexist on the register, but one party's mark may be blocking the other. And so what they do is they will either file a fresh application, or they will assign a pending application to the same party so as to avoid a confusion objection, and then assign it back upon registration. That way, both parties have registered rights at the end of the day on the trademarks register. Coexistence agreements should also be forward-looking, because this will dictate how the parties continue to operate in Canada. There should be provisions for abandonment of marks, for bankruptcy, what happens if one party goes belly up. And it may also include undertakings to cooperate, report instances of confusion in either case. And typically, it will include schedules of permissible and impermissible uses. We have a question regarding coexistence agreements. What weight, if any, do coexistence agreements have in overcoming examiners' objections? Unlike in the US, where they're effectively a silver bullet in prosecution, a coexistence agreement or a consent agreement can serve to overcome a confusion objection. That's not the case in Canada. And frankly, I think examiners in Canada afford coexistence agreements and consent agreements about as much weight on which the paper is printed. It is something that an examiner will consider, but the agreements typically have to include certain provisions, and they are by no means sufficient to overcome a confusion objection.
I see there's also a question about whether or not the Trademarks Office is affected by the current strike. It is my understanding that it is still open, but they have warned everyone to expect delays in processing times.
I will make one further note. I learned yesterday afternoon that trademark examination has effectively been put on hold until the strike is resolved. So CIPO is open for business. It will still accept correspondence. You're still required to meet your deadlines, but trademark examination has been put on pause. So that takes us to our question period. I see there are a few questions coming in. One question relating to statements of opposition. Is there a limited timeline that you can move to strike a statement of opposition? What happens to the opposition itself if it is struck? There's no particular time frame. It's best to do it at the outset before you agree to defend the opposition proceeding by way of counterstatement. Usually, any objection to a statement of opposition is brought immediately before the other side pleads over. If the opposition itself is struck, typically the registrar will afford the opponent an opportunity to amend its statement of opposition, but not in all cases. Where the opposition, or rather the statement of opposition, really provides no proper valid grounds for opposition, it may be struck out in its entirety, and the proceeding may effectively conclude right there and then. We have a further question here. A registered trademark has been assigned to another party. The registrant, not the new owner, recorded the assignment with SEPO. What happens in this situation in a Section 45 proceeding? So a registered trademark has been assigned to another party, and the registrant, so I guess the original owner, and not the new owner, recorded the assignment with SEPO. What happens in this situation? So it will depend on when the assignment took place. In a cancellation proceeding, it is the registered owner of record that is required to prove use. So the registered owner at the time of the proceeding bears the onus of proving use. If the registered owner as recorded is not in fact the current registered owner, then that needs to be made clear to the opposition board in the course of the proceeding. For example, assignments can be filed in evidence. They should also be recorded in the course of the proceeding to clear things up before the matter reaches the stage of an oral hearing. So unless there are any further questions, it seems we have reached the end of our scheduled time. We'll be wrapping up now. If you do have any further questions, please feel free to get in touch with us by email. We'll be putting up our email addresses shortly. And we encourage you to complete the survey when the link pops up at the end of this webinar. Any feedback, positive, negative, constructive, is always appreciated. Thank you for taking the time to join us today. And hopefully we'll see you for the June 15th webinar on fast tracking your trademark applications in Canada. We do have one final question. I think we have maybe a few minutes. I will try to get to it. It concerns default judgment, Laura, so perhaps this is better answered by you. Given the snail's pace at which opposition proceedings tend to move, what would be the best recourse where options such as default judgment, motion to strike do not work? Here's a hypothetical example. Party B, the alleged infringing party, decides opposition proceedings can drag on with a view to seeking a lower damages outcome. Party A feels it has a stronger likelihood of success if the question of ownership goes all the way to trial.
Thanks. So I guess two things. So the opposition proceedings that Graham was talking about are before the Trademarks Opposition Board. And those other tools we were discussing were things that you'd be using in the federal court. So I'm not sure if I've understood the question correctly. But if you were in the federal court, certainly if a party was one party's wants to have something heard shorter in a shorter manner, and they're maybe looking to use probably more of a summary judgment or a summary trial procedure for that purpose. And the other party feels that it should go all the way to trial. Effectively, that would be one of the arguments that the party A, in this case that you mentioned, would contest that motion for summary judgment or summary trial. So in summary judgment, they'd have to be able to demonstrate that there wasn't a genuine issue, or that there was a genuine issue for trial, pardon me, in order to get it to go all the way to trial. In the summary trial, the process itself, one of the components is that it is a matter suitable for summary trial. So the parties would already have to speak and convince the court to that.
I should add, to address the question, one thing, in fact, the only thing that is at issue in an opposition proceeding, it's not ownership, it's registrability. So the registrar will consider only whether the applied for trademark is registrable. They won't make any rulings on who is the proper owner of the mark. It is only whether the applicant's applied for trademark is registrable. So if the relief sought is a declaration of ownership, that is something that should be sought through the federal court. So barring any last-minute questions, we wish to thank you all very much for attending. If you do have any follow-up questions, feel free to get in touch by email. Our email addresses are in the webinar chat. We thank you all very much for attending. Enjoy the rest of your afternoon.